Good morning, ladies and gentlemen. Welcome to Polish Institute of International Affairs webinar entitled Frozen Russian Assets, which will, by definition, as the title suggests, discuss the issue of the frozen Russian assets, which is analyzed in the most recent report published by PISM. My name is Marcin Terlikowski. I'm head of the research office, and my role here today will be just to moderate this webinar to assure that it will run smoothly and to present the report and to discuss the issue of the frozen Russian assets. I have the pleasure to host today to introduce to you Dr. Stefania Kolasz, who is an analyst in PISM dealing with international law and specifically being the co-author of the report, which has recently been published on PISM website, and you may find links to the report and comments regarding the report on our social media. And Nigel Good-Davis, who is the IISS, so the International Institute for Strategic Studies, senior fellow for Russia and Eurasia, also a prolific author on the Russian policy towards Europe, on the Russian invasion of Ukraine, on everything Russia, I could say, interested on the issue of Russian frozen assets. So thank you, Nigel, for agreeing to join us during this webinar and provide your insights, your comments on the report. Well, the issue of the frozen Russian assets has been in the media for quite a long time. And the discussion about what to do, how to best utilize this money erupted. Needless to say, we have not, or the leaders have not reached a consensus on what to do, on how to best utilize this money. But there is a general idea that some form of leverage, some form of utilization of these assets is necessary because simply of the fact that Russia has blatantly broke international law by its armed invasion of Ukraine. And at the same time that Ukraine deserves or is in full position to demand damages to be paid by Russia for the horrific destruction of Ukrainian infrastructure, for the loss of life of civilians, non-combatants targeted in Russian attacks. So there is a general, again, among the most of the leaders of the let's say politically defined West, but also among the experts and commentators, there is a general idea that this money should not return to Russia, that it should be used to make good for the damages, for the loss of life, for the breach of international law, for undermining international peace and stability. The problem is we don't know exactly how to do it. And the PISM report provides a number of answers, a number of suggestions on how, in which way the frozen Russian assets could be used, as I said, to meet the political goals of the West, and political goals, of course, linked with the defense of Ukraine and linked with the situation with the post-war, hopefully, situation of Ukraine, which will require the make good for the damages. So, if I may first turn to Stefania and ask you to tell us what are the findings of the report? What is there what you recommend as regards the ways to utilize best the Russian frozen assets? Stefania, the floor is yours.
Thank you, Marcin, for the introduction, and good afternoon, everybody. Thank you for joining us and expressing the interest in the topic that is very complex and unfortunately still up to date, as we do not have one bulletproof solution. And as Marcin said, the report is fruit of cooperation of three authors, two from PISM and one external author. And we wanted to gather all information that and analysis about possibilities of make seizure of Russian public assets happen, and ways of using those assets later on. We believe that the debate among G7 member states and participants need a new impetus. So just to give you a brief overview of the report, I will summarize the content of the report and key takeaways. But just to start to show you how we think about the topic, I would like to draw your attention that we are searching for legal grounds for expropriation of Russian central bank, but we are searching for justification that would be useful to build our credibility as as Western countries, organizations. We are searching for this justification to build our positive and credible image to our partners that are not convinced, basically global south. And it's not a justification for Russia itself. We are not really taking into account Russia's possible reaction, because no matter how legally would behave, we believe that Russia will use it just for the purpose of its domestic propaganda, or even more, to provoke its retaliation. So bearing this in mind, we start from mapping Russian central bank assets held in various jurisdictions, with particular focus on G7 members. And what's our key takeaway here is that actually Russia has been preparing and to its resilience in terms of economy and finance since 2014 already. So it was exchanging the place of storing its central bank assets to different jurisdictions that probably would be more favorable to its behavior later on, or exchanging it to gold held in different jurisdictions than those that would be most certainly opposing its aggression. And what's concerning here is actually that depending on source, we have different numbers. So we cannot really say exactly which states have frozen what amounts of money. We have some general overview, but member states of the EU or G7 are generally reluctant to share the information of the amounts of Russian frozen assets. Then, taking it into account, we focus on some legal aspects. So first and foremost, we talk about state immunity, that it's a main trigger that would block our reactions to Russian full-scale invasion on Ukraine, allowing us just to freeze the assets, but not to seize them totally. It's very strong protection granted by state immunity that is also extending to central bank. And here there are some ways to expropriate Russian assets, but those are just very tiny paths because, for example, we may argue that some of those amounts are used for business rather than state purposes, and this would trigger applying different legal regime to protection of those assets. But those are very minor issues and needed to be decided on case-by-case basis. So it's not a viable solution per se. Then we pass to examining the EU and its partners' actions taken towards Russian central bank assets. And here the positive note is that actually the reaction was very quick. The decision was taken to freeze those assets, and here we have consensus. But what's problem here is that we actually don't know what should be the next step. We have different approaches taken by different countries, and even among EU member states and even among its institutions, we do not have the strong consensus of how to proceed with those frozen assets. And the arguments against using them are mostly political, economic, and legal. And this brings us to the next chapter when our co-author deals with the economic consequences of using the frozen assets. And what's the key takeaway here, that maybe the concerns about the credibility of Eurozone and about US dollar as those reserve currencies are exaggerated, because still, even if we proceed with seizing Russian assets, those jurisdictions are the biggest, the most credible ones. So the outcome of this action should be, especially in mid and longer term, that visible. Then, of course, we have some legal considerations. So the way how to justify seizing Russian state assets. And here we take into account various scenarios. And the bad news is that actually none of those scenarios is 100% flawless. But on the positive note, there are some possibilities in place, and we just need to be a little bit more creative in interpreting them and be maybe more courageous to shape the current situation on regarding international law. Here we are talking about first and foremost countermeasures, then collective self-defense, but also some subsidiary means like applying doctrine of necessity, or, for example, treating Russia as a state sponsor of terrorism that would enable us to seize its assets. Of course, depending on the legal grounds we apply, we will be able to determine how to use the frozen assets. And what we advise here is not to focus only on one legal solution, but to apply all of them, and to try different scenarios to make it more legally safe, but also economically safe. We recommend to do it on step-by-step basis, so not all at one go, but adopt a stage approach, which is especially relevant in terms of applying countermeasures that by definition should be revocable. So it would bring smaller economic risk if we proceed on stage approach. And also to use all possible subsidiary justifications, such those that may be found in, for example, Council of Europe conventions regarding protection of environment that was seriously damaged by Russian aggression on Ukraine, about human trafficking, about, again, financing terrorism. So all those solutions are in place. They would be difficult to apply because there are always some gray zones of international law that it's pretty vague on those matters. But we need to have courage to specify its application. And just to conclude, I would like to leave you maybe with very open question that, given the fact we are very concerned that we may create a very dangerous precedent by seizing Russian state assets, we probably create even more dangerous precedent of leaving the aggressor unpunished. Thank you.
Thank you very much, Stefania. I noted a number of interesting observations, conclusions ideas. And starting with the latest, yes, as a matter of fact, there has been a lot in the public debate on the need to avoid a dangerous precedent by seizing Russian assets and utilizing them for any kind of compensation, broadly speaking and generally speaking, to Ukraine, for Ukraine. But I very much think that what this debate has been lacking was the international law perspective, in the sense that not or leaving the aggressor unpunished may be an even more dangerous precedent for the future. And of course, while there is no legally binding instrument regarding liability or universal instrument regarding liability of the states, there is a customary international law, and there have been precedents in the past which made the aggressors responsible politically and liable economically. Yet, in the current political circumstances, we may find the Russian assets, frozen assets, the only way to actually hold Russia liable, because for any other kind of, I don't know, a special instrument like a special tribunal, the international consensus may be even weaker. So, well, I picked the very last the observation argument you made, but there have been, as I said, much more in your presentation. There are even much more in the report, which, by the way, you may find it online on the PISM website, and links to the report you may find on our social media. But without me speaking anymore, now if I can ask you, Nigel, again, thank you for agreeing to connect, to comment on the report. What do you find particularly interesting in the report? What can you say about this lack of consensus of how to proceed, and the recommendations which Stefania, together with Szymon, together with Grzegorz, made in the report? Nigel, please.
Yes, thank you very much to you, to PISM, and to Stefania for the opportunity to share some thoughts on this. It's a subject I take a close interest in and have written about at some length as well. And we, about a year ago, at the IISS, published a major report by Philip Zelikow and a number of leading international lawyers that address the legal aspects of this. The first thing I'll say, it's very welcome to have a Polish voice in this conversation. It is very, very important that countries on the front line of Russia's war against Ukraine step up, given the strategic urgency and importance of the stakes here. Maybe I'll say a bit more about that at the end. And I hope that that Polish voices will be an important part of a debate which I think for too long, at least within the EU, has been relatively dominated by some of the more skeptical voices. And to that extent, I think those who see merit in the case for transfer of assets, I prefer that term to seizure, because it's not really that EU countries are suggesting, or anyone is suggesting, that these assets should be taken and held by the countries where these assets are deposited. Rather, the proposal is to transfer them to Ukraine. So transferred. And I think too long, a small number of large states in the EU resistant to transfer have sort of dominated the politics of it. So more pleas from Warsaw will be very welcome. The first thing I'll say is that the report does a great service early on in amassing a large number of sort of statistics and details, as well as a summary history of the diplomacy of this issue, and that's a valuable service, because a lot of this detail was sort of scattered around multiple sources, and to have it in one place as a sort of reference for the future is a great service to us all. Now, on to the substance of the report's arguments. The kind of the structure of arguments around this issue has always been around two questions. The first is, can we do this? Are we legally permitted to? This is a legal question. And the second question is, should we do it? And that question asks, even if we can legally, if we can find a safe legal path to do so, is this the right and sensible thing to do, or are there pragmatic policy reasons why we shouldn't, specifically financial and economic ones? And the report rightfully addresses them both. I will offer the view that, interestingly, compared to most other arguments and commentaries that I have seen, especially as the debates have evolved over the past couple of years, the report approaches them or reaches slightly different conclusions about each one. And what I mean by that is that in the kind of the universe of analysts that I am involved in, generally speaking, the view is a sound and clear legal foundation for transferring Russia's assets to Ukraine has been found under the doctrine of state countermeasure. And a lot has been written about this, a lot of, to use the word you just used, creative, but also sound legal argumentation has been developed to justify this. And the real reason why there is quiet reluctance among some of the larger EU member states in the western half of the EU, why there's reluctance to go ahead with this, is based on more pragmatic financial and economic considerations. Now, as I read it, the report is more confident that the financial and economic arguments and objections can safely be discarded than it is confident that there are no real legal objections. In other words, as I read it, the report is more cautious about the legal justification than about the economic and sort of financial justification. So that was an interesting contrast to me. I'm glad that the report is fairly dismissive of, or at least reaches a clear view about why we should not worry too much about, for example, the effect on the Eurozone, the implications for future financing of Eurozone debt and the like. So I'm quite pleased to see that there are strong and clear arguments there to undermine the pragmatic objections to transfer. And I agree with that. On the legal arguments, I think one point I would respectfully take issue with is the emphasis on the problem of reversibility. Now, others have written about this, and I'm not a lawyer, but as I understand it, the criterion of reversibility in the use of state countermeasures under international law should not be read as saying what has been done as a countermeasure should be undone in the sense that all of its consequences should be reversed. Reversibility means that if a countermeasure is applied, it should at some point cease being applied when, at the point that the state that is being targeted ceases to engage in the behavior that triggered the countermeasure in the first place. And that would mean at the point that Russia ends its invasion, then it would no longer be justified for sanctioning states to take any more money, to take any more of Russia's money that it can find. In addition to that, and more important, as I read it, the International Court of Justice, in some of its judgments, has not made reversibility a categorical requirement. It has merely stated that countermeasures should be reversible as far as feasible, or as far as possible. As far as possible is the wording that I've seen in case judgments. It's not an absolute requirement. And again, I'm not a lawyer, I won't go into the details, but others have written how there are strong grounds for arguing that reversibility does not mean returning the money to Russia. But finally, even if one were to take the view, which I don't and others don't, but even if one were to take the view that in this case reversibility of the countermeasure of transferring Russia's assets to Ukraine means you have to return that money to Russia, that simply means, or could be constructed to say that money will be returned to Russia after Russia pays the money, the reparations that it's obliged under international law to pay to Ukraine. Now, that's a sum of money that far exceeds the amount of immobilized Russian central bank reserves in the EU. So you could say, okay, we're seizing this money, we're transferring it to Ukraine, we will give it back to you. In that sense, it will be reversible, but only after you've paid the reparations to Ukraine. So that would satisfy even a hard reading of the reversibility criterion, while also allowing transfer in the meantime as a state countermeasure. And in fact, the existing G7 position is a version of this. The G7 says that the reserves that were immobilized in February 2022 will remain immobilized until Russia pays compensation to Ukraine for the damage it has done. So if you consider the original immobilization as a state countermeasure itself, Russia has been deprived of that money. There's no reason in principle not to go further and say, now we're giving it to Ukraine, and Ukraine will get to keep that money until such time as Russia pays the full amount it owes in international reparations. In effect, it would be a kind of a paper transfer. In effect, the money that Russia has had seized from it and transferred to Ukraine would offset the total reparations that Russia would be obliged to pay to Ukraine. In effect, Russia would have to pay even more because the total sum of its reparations exceeds the total sum of immobilized reserves that would be transferred to Ukraine. So I personally would be very cautious about suggesting that the criterion of reversibility should in any sense be considered an obstacle to going ahead with orderly transfer of this Russian state money under the doctrine of state countermeasure. One more point on this, and again, this is something which I and I think some others take a different view. The report suggested that if such transfers were to take place, they should be done gradually and in stages. Now, I don't see an argument for doing that. And I do see a strong argument for making all of that money available to Ukraine immediately, which is in desperate financial straits and military straits as well. It urgently needs this money to keep its government functioning and also to keep its defense as well provisioned as possible. Also, importantly, it sends a political signal of resolve to Russia. If we take all this money, we are showing immediately in one go and give it to Ukraine, that sends a signal about how clear and determined and how strong our political will is. On the contrary, if we do not do that, if we do not take Russia's money, we are sending a signal of weakness. That we, whatever our words, however many photo ops we have with President Zelensky, in fact, our resolve is so weak and uncertain, we cannot even muster the strength to take Russia's, the aggressor's money, and give it to the victim. So transfer to Ukraine has a dual function. It's economic and financial. It provides Ukraine with urgent needed help and incidentally eases the burden on Western taxpayers of supporting Ukraine, which is very important. But secondly, it sends a political signal of resolve to Russia and to other potential aggressors out there. And I think the report does make the useful argument that taking this money sets a good precedent. It's not a bad precedent, it's a good precedent. It tells everyone in the world, if you carry out a gross violation of international law, erga omnes, then you are liable to face losses of your state assets. I think that's a good precedent. Finally, and I'll finish on this point, we can and we should talk in detail about the legal and economic and financial arguments, but we must never lose sight of the larger strategic, moral too, but also strategic, and for us, self-interested security issues. We face a situation where Ukraine's future and Europe's future security are imperiled. So I would ask I would ask those who object, under what circumstances, if you have all these objections now, are there any circumstances? Is there anything that Russia might do that would cause you to say, okay, we should take this money? What if they invaded us? Would we take this money or not? We need to understand the extent of the stakes here. At present, European governments have ordered their priority of risks so that they consider it more risky, in fact, too risky, to take Russia's state money to give it to the victim, but they do not consider it too risky to provide high-tech weapons systems that kill large numbers of Russian soldiers. That's a very strange ordering of risks. And the final point, and I really will end on this, just to sharpen the focus on the strategic contradiction between giving weapons of war to Ukraine, giving weapons of war to Ukraine, but not giving Russia's money. Imagine the future historian writing about this period of history, say in 50 or 100 years' time, and saying, Ukraine suffered these horrible consequences of Russia's invasion. Perhaps in the worst case, Europe suffered terribly too. And all of that time, we had hundreds of billions of euros of the aggressor's money available at our disposal and did nothing. What do you think the verdict of history would be? So yes, there are legal concerns, I think overstated. There are economic and financial ones. I think the report has persuasively shown why they are not too significant. But ultimately, to govern is to choose. There is no risk-free solution, and we have to understand and approach these issues with a larger sense of what the longer-term existential stakes are for us all. Thank you.
Thank you, Nigel, for an extensive review of the report. Thank you for your words of appreciation as regards parts of the report and parts of the recommendations which you like the most. We really appreciate it. Well, I find it very interesting that in many areas, for instance, as regards the pace of the process regarding the seizure and utilization, if I may use this general word, of Russian frozen assets, you advocate for being more radical, faster than the authors of the report suggest. This is a very good ground for further discussion. And as a matter of fact, we would like to have a little bit of discussion here. So I would like to ask the members of the audience to type in the questions in the chat function after it's been a few years since the COVID pandemic, so you may forgot this feature, but there is a chat button. You may type in the question. I'll really read it. But before we get these questions, let me start with let's say one thought request for your reaction. Well, you mentioned, both of you mentioned the vast needs of Ukraine, both as regards the reconstruction of its infrastructure and the, let's say, everyday needs of the state apparatus to continue functioning. Simply, the money is needed to continue the Ukrainian state's everyday activities, so to say. The public sector needs to pay wages, of course, for instance. At the same time, there are the growing needs of Ukrainian defenses. So, well, assuming that we would finally get the consensus on how to utilize Russian frozen assets, either regardless if it is step by step, very, very gradual and let's say kind of orchestrated approach, or it is a very fast, rapid move. Would you prioritize reconstruction? Would you prioritize rearmament and military support for Ukraine? Or perhaps would you find another, let's say, venue, another priority for these assets? Stefania, if I may ask you to go first.
So maybe I will take the legal approach. So basically, the answer depends on which justification you choose to transfer the money. So if you are acting in collective self-defense, or you are applying countermeasures or doctrine of necessity, those measures would point rather to military spending than, for example, the reconstruction. On the other hand, if you apply those measures that I call subsidiary, so for example, punishing the state sponsor of terrorism, this gives you more possibilities to spend the money to compensate the victims or to rebuild Ukraine. Obviously, you can mix those grants and direct those funds in different directions, but strictly legally speaking, it will all depend on the legal ground you applied just to transfer the money.
Okay, thank you. Stefania, Nigel, what would you say is a priority?
It's not for us to decide. This will be Ukraine's money if it's transferred. Again, it's not EU or anyone else's money that we are telling Ukraine how to use. It's like reparation. I mean, in effect, this taking these assets and giving to Ukraine is a way to preemptively, or at least before, not preemptively, but before the war is over, to compel Russia to pay part of the reparations that it owes. Now, no one else should tell Ukraine what its reparation needs are. That's for Ukraine to decide. It's the country that's been damaged. It's the society that's been traumatized. It's up to Ukraine to do that. The fact that we can do it in wartime adds the further possibility that we can, or that rather that Ukraine can use that to make or purchase armaments. I see no problem with that at all. By contrast, the problem with emphasizing that this should only be for post-war reconstruction is that post-war reconstruction presupposes a successful outcome to the war. And that hangs in the balance right now. So the priority should be to ensure that the necessary preconditions for a successful reconstruction are created. And that means that Ukraine finds itself in a position at the end of this war as favorable as possible. I see no reason on those grounds why Ukraine should not be able to use some or all, but it would probably be some of that money on its own present urgent military needs. There's a further, sort of more diplomatic point here. that if Ukraine has, and consider, the amount available here is greater than Ukraine's current total national income. It's a lot of money. And it can use some of that to buy weapons from the United States, as well as Europe, from us all. But to the extent that there'll be an American component to that, I think that would be a pragmatically useful way of keeping the White House interested in and supportive of Europe's own security interests with regard to Ukraine.
Okay, thank you, Nigel. The reason I asked this question was that there was, and I would like to push both of you a little bit on that issue too, for the sake of having a discussion, but also being aware of the limited time we have. There have been speculations, there have been ideas that perhaps this money should not be given out straight away to Ukraine, but also used, for instance, for a special as a special way to another rearmament of Europe. There was this kind of notion in the discussion that this money should not necessarily be only used for Ukraine, like giving it away to Ukraine for the needs of the reconstruction, for the needs of the Ukrainian rebuild, reconstitution of the Ukrainian military, but actually that there can be more, let's say, beneficiaries of the utilization of the Russian frozen assets, because the violation of international law, which Russia perpetrated, right, the full-scale invasion, act of aggression against Ukraine, has the consequences for international peace, and often constitutes a breach of the principle regarding the international peace. So, would you say that this money could go, if there is a consensus, only for Ukraine, or that it can be broader, let's say, bigger number of beneficiaries? And again, if I can ask you, Stefania, about that, and then go to you, Nigel.
So maybe again I will speak to my legal perspective, because it also shows different angle of looking at things. So here again I would say that depending on the justification we use. So if we use collective self-defense, I believe that those money could be spent on not only on the Ukraine military spending, but for example on European one as well. And as far as countermeasures are concerned, I would say that intuitively I'm more convinced to use it to, for example, secure a peace deal, or also use it as payments eventually to the victims of the conflict. So depending on again how we interpret the provisions, but the scope would be rather narrow to use it collectively, or only for the EU or G7 partners, and it is more convincing to transfer the money to Ukraine, in my opinion.
Thank you, Stefania. Nigel, would you agree?
Yeah, again, unlike Stefania, I'm not a lawyer. I'm aware of, and I've read arguments that suggest that under the doctrine of state countermeasure, some other countries have suffered injury as a consequence of the full-scale invasion, and in principle, therefore, would be entitled to some of these assets. In practice, politically and diplomatically, I just think that would be too difficult. It's easy to see how that would descend into some kind of unseemly wrangling, dispute of some kind among Western partners. It could become quite ugly and detract from the urgent and underlying need, which is to ensure Ukraine's survival. So I share the view, Stefania's view, that the simplest, cleanest, morally and legally most unambiguous position is that Ukraine, which has clearly suffered unimaginable horrors and continues to daily, is entitled to the money, the assets of the aggressor.
Okay, thank you, Nigel. As we're running out of time, let me ask the one final question, which pertains a little bit to the future and to the kind of precedent issue which you both mentioned. Stefania, to you more as a international lawyer here at PISM, do you feel that this kind of action, if successfully taken, so the utilization of the assets, regardless in what kind of pace as we discuss it today, do you feel that it may contribute to establishing a new a rule, of course, in the international, of course, not a codified rule, but a customary rule, which may come out as an element of let's say, a deterrence towards rogue actors who may want to undermine international peace and stability? And the same question to you, Nigel, but more on the defense and deterrence side. So if we read the debates today among the scholars, experts, political leaders, which say that we're going into the international relations model in which there will be competing orders, and some of the orders organized, let's say, regionally, pan-regionally organized around actors who question the current rule-based international order, that some of these areas may actually kind of assume that use of military force in pursuit of some interest is legitimate, or at least should not be questioned. I mean, as we can see, a number of international actors seem to go this way in their policy towards Russian invasion of Ukraine, either by being silent or by kind of suggesting Russia was right, so to say, to do it. I mean, would this seizure of the assets contribute to defending the rule-based order? Would it contribute to defending the terrorists? So a more legal aspect of the question goes to you, Stefania, more, let's say, a strategic one to you, Nigel. So how about we start again with you, Stefania?
Well, to my belief, it's needed. The precedent is needed to be created, but just seizing or those assets or transferring them to Ukraine by G7 members, it's unfortunately not enough. It would politically work as deterrent, perhaps, but on legal grounds, we need some more consensus. So it should be universal consensus at best. Of course, it's impossible to secure it nowadays. But if we would be able, so for example, adopt a resolution of General Assembly of the UN, because again, in Security Council, it wouldn't be possible. Such a resolution of General Assembly could create a very useful precedent that could then create a legal norm. But just the action of G7 members is just the first step.
Thank you, Stefania. Nigel, over to you.
I'm not sure I fully understood the question, but if the essence of it is that transferring assets in this case can bolster rather than undermine international law by setting a precedent about the consequences that gross violators of basic rules, I mean, unambiguously basic rules, basic norms, erga omnes actions will suffer, then, I mean, this is clearly a way of bolstering the international order. It can, in some sense, be thought of as another security measure. It's a little like, it's a loose analogy, one would need to think it through, but it's almost a little like a kind of Article 5. If among NATO members, for example, if an attack on one is considered an attack on all, that strengthens the international order, that means that an act of aggression on one will be met with a response from others. Why should an attack by military means against Ukraine not be met by a retaliation with economic measures, among others? In effect, it's a form of sanction. Sanctions also are, in their own terms, state countermeasures. This is just one more of that kind. Sanctions are uncontroversial to us. I don't see why this other economic and financial measure, the transfer of assets, should be any more controversial.
Thank you, Nigel. You understood the question properly, even if I was too chaotic. And thank you very much for that. Thank you very much for comparing and praising the notion of Article 5 and the kind of a response, which would be a kind of a deterrence measure as well for the future, for any future actors who would calculate risks and opportunities regarding a potential armed action against any other sovereign state. Well, I'm afraid we have run out of our time today. So what is left for me is to say big thank you to you, Nigel, for agreeing again to join us to comment on the report, for your comprehensive overview of the report. And to you, Stefania, of course, as the co-author of the report for presenting the main findings, presenting the recommendations of the paper. Thank you. Well, what is the last thing left is to make our audience again aware that the report is available on PISM website. You can find the link on it to this publication on our social media. Please visit the website of PISM then, and please follow our social media accounts for the link and for much more news on PISM activities of PISM publications. Thank you very much today. Thank you, Stefania. Thank you, Nigel.
Thank you. It's a pleasure. Take care.